participants asked if you had filed an Article 78 to force compliance with the FOIA requests.
Well, we haven't done that. We've, the first step is to appeal in the, to the appeal process. And then after that's done, then we can file an Article 78. And so I think we're probably ready to do that now.
Cool. Can I ask all the participants to turn their cameras on, those that can, that don't have technical problems? Scott, a question for you. What is the status of right now of the lawsuit, the FCC lawsuit with EHT and CHD? You're muted.
The short answer is they're sitting on the remand. That decision was rendered in August of 2021. Soon thereafter, Environmental Health Trust in November filed a motion to reopen. No action has been taken on it. We intend to be filing a motion adding on to the EHT motion in fairly short order. They don't want to deal with this because they will indeed have to look at the science. And if they look at the science, then they're going to have to accept that their current guidelines don't cut it.
John, can I just say something?
Of course, Julian.
Because I skipped a slide and I just wanted to make what I thought was a useful point. To give the participants what I feel is a really a powerful tool in advocacy and negotiations. And that is, if you see this entire process as a negotiation, one of the most convincing or powerful tools that what I call the shadow game players use is the assertion of false narrative. And we see this as a theme running through this entire discussion. Our hands are tied. You're supposed to believe that because it disables. Look how disabling it is. We are closing the digital divide. They're not closing the digital divide at all. They're actually, as Odette said, expanding it. There's no scientific proof because it's anecdotal. We have 4,000 peer-reviewed studies, and we're being told it's anecdotal. What I'm trying to suggest is this is a device. It's a negotiation device to disarm and basically disempower local communities. And it's really helpful if you can tear the mask away and show that the emperor has no clothes. The most powerful part of the narrative is the characterization of these conflicts as tragic choices. Do you want to have an advanced 21st century telecommunications infrastructure? Well, if you want to have that, then of course you have to have 5G tower 10 feet away from your child's bedroom. That's the way it's being characterized. So if we go underneath the surface, we will see that this is not a tragic choice, but a false choice. Not only do local communities have legal options, but there are viable alternatives such as Fiber First, which are actually being subsidized by the federal government.
Mm-hmm.
So I just want to make that point.
Yeah, good point. Thank you. Andrew and Scott, this is probably a question for you. Telecoms threaten all the time, we'll sue you, or they kind of make that vague, threat. How do you answer that? I mean,
I see that all the time, both vague, thinly veiled. Sometimes I've seen applications where they bring stenographers in the hearing room to try to intimidate them. And I constantly tell my local government clients, those threats are hollow, and here's why. If, for argument's sake, a local government denies an application for a wireless facility and gets sued in federal court and loses, they do not pay the applicant any compensatory damages or attorney's fees. Those threats are, for the most part, entirely hollow. The Supreme Court has ruled that you can't recover damages under the Telecommunications Act, and even creative site development companies who've tried to use 42 U.S.C. 1983, the Civil Rights Act, to say their rights are violated, they've been knocked down too. So as of now, I haven't found a single case where local government was successfully sued and paid 1 penny to the applicant, whether it was a carrier or a site developer. The only expense you have is your own attorneys. But fortunately, under federal law, actions on the Telecommunications Act are required to be expedited proceedings. These things typically last months rather than years. And as long as the local government doesn't hire a law firm who thinks the best avenue of redress is to try to extract as much in fees from their client as they can, these actions tend to be the least expensive litigation in federal court that I've seen in 30 years of practice. So any threat of litigation, generally speaking, is for the most part hollow. The only thing they get is an order from a judge ordering the local government to give them the permit to let them build the facility.
Is it, I'm sorry, go ahead, Scott.
I agree with everything Andrew said, and I have an additional answer. These local governments should not be afraid of getting sued by the telecoms in federal court. They should be concerned about getting sued in state court by their own constituents. And that is the kind of litigation that they really should be worried about, because there is the possibility of damages and fee shifting there. Further, you need to be mindful of who it is you represent here. You represent your constituents, the ones who voted you into office. And therefore, you should be concerned about advancing their interests as communicated to you by them, and as you can best do it within the law, of course. And so my second answer is, well, if you keep cratering to the telecoms, giving them everything, then, you know, there's an election coming. You might be worried about that.
What parts of an antenna are antenna application are most likely to contain false information? I love that question. It's an interesting one. Assuming you're looking at an application, where is it most likely that they're going to stretch the truth or, you know, otherwise try to...
That's a softball for me. Can I take that one? Would you mind?
Sure.
Okay, so
Cool.
right now I've seen applications from across the entire United States. And right now, I would say in 95% of the applications, they contain patently false and materially misleading information. And unless your local code gives them guidance to your board to recognize when the information is false, they're not going to have it. So let's start with the basics. Easy one, FCC compliance reports. Fraudulent FCC compliance reports are used all the time. There's 2 key criteria. Number one, they'll prepare a FCC compliance report where they allege that they'll be FCC compliant, meaning that the radiation levels won't exceed the limits set by the FCC, but they will refer to the wrong sets of limits. They'll be talking about the occupational exposure limits and not the general population exposure limits. But the more common scam they pull is the false minimum distance factor. So what does that mean? When they prepare an FCC compliance report, they talk about the level of radiation to which the facility is going to expose members of the general public, but it doesn't exist yet, so they can't measure it. So what they do is a mathematical calculation. The critical starting point for that calculation is the minimum distance factor. How close will anyone be able to get to the transmitter? And to prepare a false FCC compliance report, all they have to do is start with a false minimum distance factor, and that will create a calculation which will reflect that the actual radiation will be substantially lower than it will actually be, number one. Number two, false propagation maps is the rule rather than the exception. They will use, instead of giving local governments actual probative data like drive test data or denial of service records to prove either a significant gap or a capacity deficiency, they will use software programs like ATOL to prepare propagation maps. Now, there's nothing wrong with the software per se, but the software is easily manipulated to show maps that show anything you want. And in 95% of the cases, they show patently false propagation maps. This is not unusual. They've been submitting false data to the FCC for years, so much so that in 2020, the FCC staff recommended to the FCC that they not accept propagation maps from the wireless industry anymore without hard data like drive test data. In addition, they'll submit material misleading visual impact analysis. They'll take photographs showing a local board what the facility is going to look like and the adverse aesthetic impacts it's going to inflict. but they always omit photographs taken from the closest homes who will suffer the worst impact. So it's easy to spot false and misleading information submitted in support of applications because it's in 95% of all applications being filed today.
Let me follow up. There's other areas where there is false, misleading information. A lot of it is the information that is not there. I quite often find that their pictures, their maps, their narrative representations somehow forget to memorialize that there's a school within 200 feet. They quite often fail to recognize where other nearby facilities are. And of course, that would be useful for the significant gap or the need analysis. They quite often omit recognition of historical sites. And what I'm seeing a lot of now is they misrepresent the extent to which there is a categorical exclusion under NEPA. Nor do they address the circumstances where even though there may be a categorical exclusion, there may still be an environmental effect, thereby requiring an environmental analysis. So there's no rule. I'm sure everybody's heard it. How do you know the telecoms are lying? Well, look to see for when their lips are moving.
Oops. Okay. Thank you, Scott. Brenda, I want to bring you into the conversation a little bit. A lot of times, the telecoms talk about their wireless antennas closing the digital divide. You've had some experience with kind of bait and switch situations where there's a very low price that's offered, but it's really slow. Or tell us about your experience with that.
Oh, so where do we start there? Yes, the digital divide was mainly focused and noticeable when the pandemic hit. So usually lower income communities don't have access to internet in their homes. And before the pandemic, you had access through libraries and different places that will offer you the Wi-Fi. Now, when the pandemic hit, that's when we were able to see the reality of this, which was no internet access, no device access. And so that's when a lot of the big telecom, started using our lower income communities as an excuse to the digital divide. And so through the pandemic, there was a major deployment on lower income communities. I'm just going to give a quick example. We went through just your regular antenna search website. Prior to pandemic, I went from having 50 antennas, half a mile radius from my home, to after the pandemic, 2,000. So recently I had 2,000, half a mile within my home, and I still didn't have internet access, affordable internet access. We had the affordable connectivity program, but it's very limited and it's pretty soon will be ending because there will be no more funding. And the fiber optics was just simply not available, even though we realized going through with Fiber First and checking maps and requesting the mayor's office to share with us some of the maps, we were able to see there was fiber, but it was off, it was turned off. And so finally I got fiber in my home. And so it took an act of God, because just talking to one of the employees, the technicians, he said, just get a bunch of your neighbors calling the phone companies and say, we want fiber, we want fiber, we want fiber. And we got fiber in our block. So we're still one of the few. It's still very expensive. The Affordable Connectivity Program gives us a little bit of help because it will cover, I think, 50% of the fees. But still, we are in a very difficult situation. And again, we have thousands of antennas surrounding us, and we still don't have accessible, affordable, and safe connectivity. And then we can see the safety aspect, the hacking aspect with the LAUSD case, which was hacked, and thousands of files are jeopardized of important confidential information from children and employees. And now LAUSD is being blackmailed with that information. So again, we, you know, I know I'm going a little bit, but it's just so much that is happening in our communities. And again, I am not saying we are the only one. I've also recognized that there's communities that are affluent that might not be able to have the fiber optics accessibility. So, all right, I think that's it. Thank you.
Okay. All right. Thanks, Brenda. Julian, let me turn to you with this question. What does somebody do who's electrosensitive and an antenna is put right outside their door? Is there an ADA thing here we can claim? What can we do for these people? I'm throwing you the tough question, Julian. Just
No, if a person has, first is to kind of demonstrate with opinion by a doctor who's been trained in clinical electromagnetics, that the condition falls clearly within an emerging legal standard of what is a special sensitivity to non-ionizing radiation. So you have to have, that's the first step, is to get sound medical advice. And Sharon Goldberry and a number of other physicians in the country are really expert in these cases. So first step is to do that. The second is to be able to document who's responsible, to be able to show some proximity of relationship between the exposure and the consequences. And the third is to identify, to open a negotiation both with the telecom that is exposing this person, as well as with the permitting authority. The telecoms are actually taking the position, as we see in our cases, that they don't have to comply with the ADA. I think that's an unsound legal position.
mm-hmm.
They're saying that they're not a public utility. They're a private company, just a little private company, and the ADA doesn't apply to them. Now that's a legal position that I say is not accurate or correct. But the permitting authorities have clear jurisdiction for this. They do have authority to it, and so you have to obviously hire a good lawyer to be able to raise and prosecute the claim. But you are entitled under the law to a reasonable accommodation.
Is there a title of a particular title? Anybody on the panel of ADA that Scott, that can be used for this?
It depends on each circumstance. Title I of the ADA deals with employment. I'm not going to address that here. That would be the employees of the wireless providers. Title II would apply in the context of zoning that Julian just mentioned. The local authority is covered by Title II and is required within its programs and services to accept and deal with any accommodations. I'm not a big fan of using local zoning authorities when the project itself is on private property. That becomes a bit more difficult to bring under Title II of the ADA. But if this is something that's in right of way, that means the local jurisdiction itself is the owner of the underlying land, and therefore Title II would impose obligations on them. The problem that we face in the courts is what is the reasonable accommodation that it's due? What is it? How are they going to accommodate you? And that can become very difficult. It all depends on the circumstances of each one. I do want to mention that there are other statutes as well that apply here. There's the Fair Housing Act, Fair Housing Amendments Act. If you bought your home using a broker, and if somebody puts a wireless emitter, say on the right of way, in your front yard, on private property next to you, and it makes you so sick that you are constructively evicted, then there is a potential cause of action under the FHA. Finally, all of these wireless companies are, of course, as Brenda's been talking about, receiving federal grants. And therefore, the Rehabilitation Act applies. And its operation is very similar to how the ADA works. The difficulty here is figuring out the right place to raise it, whether it be in the zoning context or in the state administrative process, or in the courts, or the funding federal agency. That will require very careful consideration based on the specific facts and indeed what circuit you're in.
One other aspect of it is sometimes, as Odette shows, these facilities, instrumentalities are clustered. And there is an FCC rule about aggregate exposure. I don't think it's been terribly well litigated. But if you have a group of these towers or devices all irradiating this potential plaintiff, then the rule says that you look to the aggregate effect. And if any one of the individual providers more than 5%, then they have to bear the burden of showing that they're in other words, the burden shifts. They're going to have to show that they weren't responsible for the injuries. I mentioned also, we do have technology now to provide reliable monitoring, not just a one-off visit by a building biologist, but continuous monitoring. And this is a critical part of the equation, to be able to show that what is the level of exposure. And then you bring in the doctors to show the dose effect from that level of exposure to the particularly symptoms that are being reported. And then, of course, as Odette and others have pointed out, children are particularly vulnerable. And so we really have a situation where these companies have they know exactly what they're doing. They're intending this. They're intending the harm, and people are being harmed. And therefore, one needs to think, I think, strategically in these cases about the portfolio of legal options that you have, because somebody's going to break through on a tort action. Somebody's going to survive the causation challenge. You can't prove that your illnesses specifically were caused by this level of radiation. But we're getting very close because we're able to monitor it. We have good doctors now that understand this condition. And some court is going to shift the burden and say, under these circumstances, we know the source, we know how it's been transmitted. It's an air pollutant under the Clean Air Act. You're intentionally doing it. Here are the injuries. One case breaks through and you will see a sea change across the country.
I'm sure.
And finally, as Scott and others have pointed out, really there's no practical insurance available for these things. The insurance industry of all people understands how to assess risk. And they've bitten the bullet and said it's too risky to insure.
Yeah.
And this has to be and should be disclosed in 10Ks, which these companies are doing, but they're doing it inadequately.
Page
So
17 at the very bottom in tiny little print. Andrew, did you want to say something?
Yeah, I need to chime in and spread a little rain on everybody's parade and tell you that the leading situation in dealing with the theoretical conflict between the ADA and the TCA. I brought an action in the Northern District of California based upon the ADA for an individual who was living in the top floor of a condo and suffered significant adverse health impacts from exposure to RF radiation. The district court dismissed the case, and I appealed it up to the Ninth Circuit Court of Appeals, arguing that the Telecommunications Act does not prohibit application of the ADA and does not in any way adversely impact people's rights to a reasonable accommodation if exposure to RF radiation impacts them, even at radiation levels which would not affect adversely the normal person. The Ninth Circuit Court of Appeals dismissed the case and didn't make a decision as to whether or not the TCA preempts the ADA and the rights of the ADA. In what I perceive to be just an effort to make sure the courthouse doors stay closed to too many ADA filings, the court ruled that under the ADA, the only thing someone is entitled to is a reasonable accommodation. And if the reasonable accommodation sought by a person who's being exposed to radiation that adversely impacts them while they're in the confines of their own home means the facility has to be moved farther away or power reduced sufficiently that it doesn't adversely impact the health of the person in their own home, then that type of accommodation you're asking for is prohibited, because it's prohibited as a matter of law under the Telecommunications Act, which says you can't regulate based upon environmental concerns, i.e. health concerns, so long as the facility is FCC compliant. Now, I have been considering cases in New York. I think federal courts in the Second Circuit will rule the opposite way, in which case I'm hoping to get a case to go up to the US Supreme Court to decide this. The other facet I'm looking at is a constitutional challenge, because I receive calls from all over the country from people who are in fact suffering adverse symptoms from RF radiation, bombarding them inside the confines of their own home. And my position is the ultimate right of self-defense, a fundamental right under the Constitution, is most acute in the confines of one's own home. And if the Telecommunications Act is being applied in a way where it supposedly prohibits someone from protecting themselves from harm from radiation inside the confines of their own home, it violates their rights under the United States Constitution. I am eager to assert a case of this type. I just haven't found the right case yet.
You know, it's interesting that you say that, Andrew, because CC Doucette raised the same question in the chat that I've always had. I looked at that picture of the antenna 10 feet outside that child's window,
Yep.
and I think, okay, there was no radiation here on such and such a day, and on, you know, the following day the room was filled with our. Why isn't this a trespass issue? Why isn't this a simple, you know, failure to, you know, doing away with my right to peacefully enjoy my own property?
There have been many types of challenges raised. In New York, they tried to raise one for nuisance. There was an individual who lived on the top floor of Co-op. The RF radiation, there was a facility built right outside his bedroom. The RF radiation was adversely affected him, so he brought a claim for nuisance under state law. Now, every state has a law for nuisance. In most states, the elements of a nuisance are the unreasonable interference with the use and occupancy of one's home. In dismissing that case, the state court ruled that the interference has to be unreasonable. And since the RF radiation levels intruding into his home were within the limits set by the FCC, it was presumably under the law reasonable as a matter of law, and dismissed the case. I've had several cases which I think would have been successful, but to avoid litigating the issue in each of those cases, the responsible party who owned the facility moved them and thereby basically chopped the legs out from under us before we could file the lawsuit. I'm confident at some point in time, we're going to get the right case in the Second Circuit. We're going to file it. I think the Second Circuit will rule opposite to the manner in which the Ninth Circuit ruled, and I think this will go up to the Supreme Court. I've been admitted to the Supreme Court for over 20 years. I can't wait to get a case like that up there, because I do want to protect the rights of people who are sensitive to EMF radiation.
You're not the
So-
only one that can't wait. Yes,
By the
Julie.
way, if I may say that this, particularly the area of children, where the medical evidence and scientific evidence is so strong, I think this is an area where we'll see some really creative legal work. It was written by a pediatrician in our meeting 2 days ago with an international group of lawyers and scientists who are dedicated to bringing legal cases to protect children. She wondered why this is not child abuse. The reason that's a very interesting idea is it bypasses really these causation issues. There are clear statutory rights that children have to be protected from intentional abuse. And so this is, I would call it, a new frontier of exploration, both applicable to reasonable accommodation cases as well as damage cases, that arguably is not preempted either by the Telecommunications Act.
One last quick question. I think this is a yes or no. If a citizen finds out that there was false information filed as part of an application, can the permit be withdrawn?
When you mean withdrawn, or you mean revoked?
Revoked.
Well, the problem there is once a permit is granted, it's a vested property right arising under New York state law. And that means that the local government cannot revoke that permit without affording the applicant notice and an opportunity to be heard. Most local zoning authorities and their ordinances don't have any procedures for doing that. That's the problem. Again, it always comes back to your local zoning code and zoning ordinances.
Same thing in California.
tremendous-
Go ahead. Sorry, go
Local
ahead.
governments have tremendous power available to them, but to take hold of the power and use it, you must codify procedures which enable you to do so. And that's the biggest problem to preventing the irresponsible placement of wireless facilities across the United States today.
Yeah, I mentioned that in where that kind of provision would go would be in the conditions. For example, a condition would be, if we find that you lied to us, we get to revoke this permit.
And that'd be a perfectly legal thing to put in a code, right?
Yes,
So the code should be submitted under penalty of perjury, right?
yes, that is always one of the things that we put in, requiring that it be submitted under perjury, not only by the experts that designed it, but also by whatever the wireless company is that's going to be operating it.
Yeah. We are at the 5:32 mark in New York, which is the an hour and a half since we began. The chat is full of really good questions. Fortunately, we can save the chat. I think probably what we will do is we will reconvene this panel in 60 days, come back, answer a lot of these questions that have been posed, because I think we're providing really useful and great information to the people that are attending today. And of course, we will we'll make a video or a few videos out of the webinar today, and we'll have that up in a couple of days. So I want to thank Andrew, Scott, Julian, Brenda, Odette. Thank you so much for being on the panel, giving us the benefit of your experience. And as I say, I hope you'll come back and be on a future panel with us, because we got more questions to answer. And I think this is helpful to people. I'm seeing everybody on the chat is lighting up with thank yous. So thank you everyone who attended. We appreciate your support. I will be putting up the videos over the next 24 hours, and all those of you who've registered will get an email with the link, and I'll put everything in the order that it was supposed to be and take out all the mistakes. Sorry about the technical troubles today. Thank you for bearing with us. Good night, everyone.